Marcia Zug.
Yes. Good morning. My name is Marcia Zug. I'm a professor of family law at the University of South Carolina School of Law. I'm here to talk to you about the potential implications of the law. Obviously, we've discussed a little bit about the constitutionality. We know about Roe v. Wade. But even before that, a fetal personhood bill, which would outlaw abortions in even the most life-threatening of circumstances, has never been an option with the Supreme Court, is clearly unconstitutional. Under Supreme Court abortion jurisprudence, we raise the specter of the ectopic pregnancy. That's a situation where the life of the mother is threatened, but the fetus would have no viability. Under this law, there could not be an abortion because a life begins at conception. It's well established that you cannot sacrifice one person's life to save another, even if that person is going to die. With regard to contraception, if the fetal personhood bill is passed, they would outlaw many effective forms of birth control, such as the pill, the IUD. They're the most effective forms of birth control. Again, this would be unconstitutional under Supreme Court precedents such as Griswold v. Connecticut, Eisenstadt v. Baird, which state that people have a constitutional right to make contraceptive choices in the privacy of their own relationships. We've heard about in vitro fertilization. This bill would not outlaw in vitro fertilization, but under all practical effects, it would. It would be too legally risky for IVF to continue. We have a situation of frozen eggs. Would they have rights? What rights would they have? So if I went in for fertility treatment and my eggs were frozen, would they have to be implanted? Could you force a woman to have those eggs implanted? What would be the obligation of the doctor? What happens if an egg is harmed in the process? Could he be prosecuted for murder?
Okay, that's your 2 minutes, and you wanted that, please.
Thank you. So the other possibility, legal implications have to do with miscarriage and inheritance. There are a number of legal implications of this bill well beyond abortion that could occur. Thank you very much.
Any questions?
I have a question.
Senator Orangeburg.
So, Professor, as I understand it, then, if this bill passes, what we currently think of is the Hyde Amendment exceptions to rape, incest, life of the mother, none of those would survive this bill.
No.
So, we would basically, under this bill, be empowering rapists. In other words, if somebody became pregnant as a result of rape, there would be no way for that rape victim to not go forward with carrying that child.
Yes, this would certainly outlaw all abortion. No exceptions.
No exceptions. Life of the mother. So you've got a mother who's got 7 children at home and is pregnant with one, and this one may cause her death to leave the other 6 children without a mother. There'd be no exception.
Correct.
And writ of habeas corpus, if you've got a pregnant woman in jail, would the child have a right to get their, under this, what we describe as the child have a right to get their lawyer and say, get me out of here, I don't want to be in jail anymore?
I'm not sure about that. I mean, once the child is born, I don't know if we can say that the child is actually in jail, but certainly your question is a very good one. What kind of rights, separate from the mother, would not even the fetus, it would be the fertilized egg, have?
So, I mean, in fact, we would be empowering this entity, the fertilized egg, whose mother doesn't even potentially realize is inside of her, to have rights that the mother herself would not know about.
Yes, and they could have rights that certainly that the mother doesn't have, that we've never given them before. They could rights that would cost the state a lot of money. One of the things I started talking about is if we have these eggs that have a right to life, does it mean the state of South Carolina has to pay for surrogates? Do they have a right to be implanted? What about inheritance laws? If I die and I leave my money to all of my heirs, well, does that mean my daughter's frozen eggs? And how do we separate who gets what money? We have to wait to see if that egg gets implanted, if it turns into a person. There are those types of implications that would occur from this as well.
Has there been any court, to your knowledge, any court in the United States that has ever upheld a statute that would go this far?
not at the moment, not that I know of.
Any other questions? Senator from Greenville.
Thank you, Mr. Chairman. Professor, now you stimulate the mind, much like when we were back at, in law school, but you raise a lot of questions or a lot of issues that make implications that I think we should really think about. Did you have a position, I may have dismissed it when you started talking on the legislation, did you think it was good, bad, should be passed, opposed, against?
I think it is very broad, and a lot of the implications well beyond abortion have not been thought through and will cause lots of problems down the line. Beyond the fact that it has, courts that have heard this type of legislation have found it too broad. So I think there's a very good chance if we pass this, we'd be defending it, spending a lot of money on a law that is not going to win on constitutional issues, and has then could also be brought up on all of these other issues, that there would be people fighting on the contraceptive issues, on the in vitro issues, and I don't even think that's the purpose of this law. I don't think that's, I mean, I'm reading into it, but what?
And the probate courts, for example, would have to be fighting on the inheritance.
Who knows what they would do? I mean, yes, I'm being a professor here, speculating, but you know, when you have these wills that devise, you know, to all of my heirs, well, let's say my daughter who did the in vitro work had a lot of viable eggs. So what, I had 50 eggs in there, and then, so I actually have 52 grandchildren, and my living grandchildren have to wait to see if there are another 50, and are they actually my heirs? Because my daughter doesn't want the 50 eggs implanted, but maybe we as the state of South Carolina have to implant them to somebody else. But then are they actually my heirs anymore? Because now maybe they've been adopted by someone else. It's a good final exam question.
Thank you.
Can I ask one more question?
Yes.
Senator from Orangeburg.
So, just the point blank question, is this constitutional? It has a lot of constitutional challenges that would face it. And so,
I think it's blatantly unconstitutional.
blatantly unconstitutional, thank you. So the question though, to the issue of contraception. Right now, women are prescribed contraception by their doctors. The contraception is filled by pharmacists. Would this go so far as to tell doctors that they cannot prescribe contraceptions, or pharmacists that they cannot fill those?
If it was being used for birth control, I mean, I think they probably could still prescribe it for other medical issues, but if it was being used for birth control, since it doesn't stop fertilization, it just stops implantation, then it would seem to be illegal under this, and the mothers, the doctors, potentially the pharmacists, could all be implicated by it.
Thank you. Senator Maureen.
Thank you, Mr. Chairman. Professor, thank you for your testimony. Please don't give that question to your students. It's just not fair.
Advanced family law.
Well, no, I'm not taking that. I don't do family law, so there's a good reason why. My question is this: the statute is intended, in my mind, it's intended as a vehicle to challenge Roe v. Wade. That's the idea behind the statute. I understand the maybe severe unintended consequences of the statute as it is currently written. Do you have any suggestions or advice if my objective is to challenge Roe v. Wade through this method, but not suffer the unintended consequences that this statute might create? How would you go about crafting such a statute? And I'll give you an example.
Well, I think a lot of the problems come from the fact that life is defined at the beginning of conception here. So I know you have, the abortion ban later. It's more, I mean, that's where I think there's fewer other implications. This may not be what you want to hear.
No, I'm not.
But I think a lot of this, by defining life as beginning before implantation, that's where you get so many other implications stemming from this.
So perhaps if it were defined as some place between conception and viability, that might be.
Well, that would be pushing it, but we would not raise a number of these other things. You wouldn't have problems with contraceptives, you wouldn't have the problem with IVF. You know, when eggs that aren't even in a woman are considered persons, then you can open up the door for so many other things. If we are dealing with a fertilized egg that's already been implanted, that knocks out a lot of the other, still, I believe unconstitutional under Roe v. Wade, but that's what you're saying you want to challenge. You're not looking to challenge the right to use an IUD.
Thanks.
Okay, Mr. Chairman, can I follow up? So if I hear what Senator Maury is saying, is that the issue is to get a case to be right for judicial review, which has to be an actual case of controversy. We could just say, we in South Carolina don't want to adhere to Roe v. Wade, you please take that up and rule on it. They're not going to do that. You've got to actually have something that is a controversy that the courts are going to hear. If I hear what you're saying is, if you wanted to create that, you could pass, you suggested 20 weeks, if you could pick 10, you could pick something below what Roe v. Wade authorizes now. That would make the issue right for decision-making by the Supreme Court, if they chose to take the case. And if you did that, you wouldn't have these other implications. Is that correct?
I think so. That would just be challenging Roe v. Wade as opposed to challenging all of these other ancillary issues that I don't get the impression is the purpose of the bill.
And so a court who wanted to duck the Roe v. Wade issue can always say this bill is so overbroad that it deals with this, it deals with that. We're not going to reach Roe v. Wade. We're just going to tell you it's unconstitutional on other grounds. And so, in fact, the intent is to challenge Roe v. Wade. An overly broad bill is a pretty sure way not to challenge it because courts oftentimes take the quick way out and say, we're not going to get to that big issue because on the small issue you lose.
That's what's happened in the previous cases. They haven't even gotten into the details. They've said this bill is just overbroad. This is just too much.
Okay, thank you. Any other questions? Okay,
Thank you.
thank you.